Hello guys. Today we are going to see declaration of dividend under Companies Act. These profits are can be distributed retained. Whatever the distributed profits are known as dividend. So profits distributed to shareholders, it is known as a dividend. So we will move on to directly to the provisions of the act. Section 123 subsection 1. This deals with the source of dividend, from where you can give the dividend. Number 1, from the current financial year profit. Yes. Second, previous financial year undistributed profit. Third, both, that is number 1 and number 2, from current year financial year profit and from previous year financial year undistributed profit, provided. So there is a proviso added in this section, an amendment in calculation of the profit should be exclude number 1, unrealized gain. Unrealized gain should be excluded in the calculation of the profit, that is number 1. Notional gain has to be excluded. Unrealized gain should be excluded, notional gain has to be excluded, and the revaluation of the asset that should be excluded. Any changes in the revaluation of asset, because of that profit increase, then that has to be excluded. And this is very important point, in the carrying value of the asset or liability, this measurement is done because of at fair value, because of the profit is increased, then that has to be excluded in the calculation of the profit. Fourth point is the money provided by the CG or a SG for the payment of the dividend by the company in pursuance of a guarantee given. Guarantee should be given by the government. So money provided by the CG or SG, but the point is in pursuance of guarantee by that government. Next comes the question that is it necessary to transfer certain percentage of profits to the reserves when they declare the dividend? Is it necessary? So it is not necessary. Company may, before the declaration of any dividend, can transfer percentage of profits for that financial year, as it may consider appropriate to the reserves of the company. So it is the answer is company may transfer. So the provision provides the word may, that means it is not mandatory. MCQ probable questions. Then comes, what is the percentage amount? What is the percentage? This is at the discretion of the company. So at the discretion of the company, percentage can be fixed. One more important point is about the previous year's losses. If company has previous year's business losses, or it has a depreciation losses that are not provided during the previous year, their set off against the profit should be set off against the profit of the set off against profit of the current year. So without that, dividend cannot be paid. So again, this is a MCQ probable question. Unless previous year losses, that is business losses or depreciation losses, and were set off against the profit of the current year, dividend cannot be paid. Which company is it for? Applicable to private company? Yes, applicable to all companies. Just comes to a company is there, but that company wants to declare the dividend, but there is a inadequacy of the profit. No enough profit is there, or it is a absence of the profit during the year. So what to do at that time? That time the concept comes from the accumulated surpluses, dividend out of accumulated surplus. Company previous year 1, previous year 2, 3, 4, they may have certain accumulated profits put it into free reserves. At the 5th year they want to declare the dividend, but they don't have the adequate profit, or they don't have a profit at all. So inadequate profit, they don't have adequate profit, they don't have profit at all. That time they can use this free reserve accumulated during previous years, but the condition is it should be in free reserve. That is the first condition, free reserve, and they should follow the rule in order to declare the dividend out of accumulated profit. They have to follow the 4 rules. That is, first rule is about the rate rule, second one is the withdrawal rule, third one is the usage rule, fourth one is balance rule. These 4 rules has to be satisfied in order to give dividend out of accumulated profit. So first rule is a rate rule. Should not exceed, shall not exceed the average of rates 3 years, average of the rates of the 3 years. Immediately preceding that year. So important point, average of the rates 3 years. 3 years, what 3 years at dividend was declared, that is a very another important point. 3 years where dividends are declared. For example, 10% year 1, 10% year 2, 10% year 3. That means 10 plus 10 plus 10, 30 divided by 3 shall not exceed 10%. That is the one case. But in another case, year 1 10% given, year 2 no dividend declared, year 3 10% given. At that time, this is immediate preceding current year. Okay, what you do, 10 plus 0 plus divided by 3. Rule will not applicable to this. Rate rule not applicable because dividend is not given in this year. So average should be 3 years, but in that 3 years dividend has to be declared. That is the first rate rule. First of all, they cannot give 11% here, so that is the first condition, shall not exceed the average rates of 3 years. Second, immediate preceding 3 years they have to declare the dividend. So next rule is withdrawal rule, correct? Rule 2. This is concerned with the amount. Amount should not exceed, that is dividend amount, whatever the should not exceed the paid up capital and free reserves 1/10. So amount should not exceed 1/10. whatever the amount to be drawn from such accumulated profit shall not exceed 1/10 of the sum paid up capital and free reserve at the balance sheet date, whatever audited balance sheet date. Next comes usage rule. So whatever the amount drawn first should be utilized to set off of the losses in case if any set off of the losses of the financial year, current financial year. So if the from the reserve free accumulated profit they want to give the dividend, then first utilization, if there is any losses, set off the losses, then you can give the dividend. Fourth one, balance rule, correct? Last rule, balance rule, that is balance after giving the dividend in the free reserve should not be less than the 15% of the paid up capital, should not be less than. So after withdrawal shall not fall below 15% of its paid up capital. Again, this is same at balance sheet date, audited balance sheet date, financial statement. You cannot give 10% of the paid up capital on the free reserve. After giving, it shall not come, free reserve shall not come less than, shall not fall below 15% of the paid up capital. So these are the four rule. First rule with regard to the rate rule, average of 3 years cannot be exceeded, that is with regard to the rate. Withdrawal rule with regard to the amount cannot be exceeding 1/10 of paid up capital plus free reserve. Usage rule, first to be utilized for the set off of the losses in case any losses were there. Last rule, balance free reserve shall not fall below 15% of the paid up capital. If four rules are satisfied, then dividend can be paid out of accumulated profit. Next we will move on to interim dividend. Amendment is happened here in this provision, interim dividend, section 123 subsection 3, correct? What happens interim dividend? So board of directors of a company may declare interim dividend during the financial year. The thing is, amendment is, big changes happened in the interim dividend. See, let's suppose say this is the financial year 31st March 2019, financial year end 30th September 2019 is a AGM. So Amendment Act 2017 says in this period interim dividend can be paid at any time during the period from the closure of the financial year till holding of the annual general meeting. Interim dividend can be paid. Once again, at any time during the period from the closure of the financial year till holding of the annual general meeting, interim dividend can be paid. Dividend means interim dividend also, that is a simple point. So interim dividend can be paid out of the profits of the current year. So out of the profits of the financial year in which such interim dividend is sought to be declared. So it can be paid out of profits of the current year, or provision mentions surplus in the P&L. That means what? Previous years accumulated profit, that is the interpretation, correct? If it says surplus in the P&L, that means surplus included from the previous years, right? Year 1, year 2, year 3, year 4, previous years, that all credited in the surplus in the P&L. So that means previous years accumulated profit. So the interim dividend can be paid out of the profits of the current year and the surplus in the P&L, that is the previous year's accumulated profit, or out of profit generated in the financial year till the quarter preceding the date of declaration of the interim dividend. That means what is the previous quarter? We have quarter here from April, May, June, that is a quarter. July, August, September, that is also quarter. So it says out of the profits generated in the financial year till the quarter preceding the date of declaration of the interim dividend. If interim dividend is paid here, declared here, then this quarter. From the here also, that is again very important point, interim dividend can be paid from the this profit also, profit generated here. So the wordings are mentioned, out of profit generated in the financial year till the quarter preceding the date of the declaration of the interim dividend. Next comes, what if loss incurred in the quarter? Incurred loss during the current financial year up to the end of the quarter immediately preceding the date of the declaration of the dividend. What happens in that case? In case of loss, incurred loss, that time shall not be declared. Interim dividend shall not be declared at rate higher than average of dividends declared by the company during the immediately preceding financial 3 years. Immediately preceding 3 financial years. 3 financial years. That is the same thing as a rule. A rate rule shall be applied. So rate higher than the average dividends declared by the amount during the amount immediately preceding the 3 financial year. So in this case, not a rate should be averaged. In this case, amount should be averaged. Amount of the preceding previous year, amount declared during the year 2, during the year 3, then averaged, then average should be converted into rate. Okay. In case of accumulated profit dividend declaration, rate is averaged, simple average. Here amount is average. One more thing is example, immediate preceding previous year 1, previous year 1, previous year 2, previous year 3. Dividend declared 23,000. No dividend declared. No dividend declared. Whether can we take average? Yes, any one of the year dividend declared, then it has to be averaged. But in that before rule, we will see that one. Here rule will not applicable because of the 1 year dividend is not declared. But in this case, 1 year dividend is declared. Any one of the years, if the dividend is declared, that has to be averaged. That is in the case of a loss. Next comes a depositing of the dividend. That is the section 123(4). Okay, dividend including interim dividend deposited in the scheduled bank, not unscheduled bank. Separate bank account has to be created, deposited in the separate bank account within 5 days of the declaration of dividend. So here MCQ probable question. Next comes subsection 5. Subsection 5, payment of dividend. So payment of dividend can be in cash, check, warrant, share warrant, warrant, dividend warrant, or in electronic mode also. But given to only to a registered shareholder or his holder or banker. So this is all about the payment of the dividend. Now question comes, can the dividend be paid in kind? Can dividend paid in kind? Answer is no, only cash should be given, or this mode. One more side point is, in case of capitalization of profit, company can do so in order to issue the bonus share, or in order to make it fully paid shares, they can capitalize. Next comes prohibition to declare the dividend. Section 123. This section we finished. Subsection 5. Now 6. Prohibition to declare a dividend. To whom? Company not compliance with the section 73 is not complied, or section 74 is not complied. Section 73 is about the prohibition on the acceptance of the deposits. Here prohibition on the or a failure to repayment of deposit before the commencement of this act. So if the company fails not comply with the section 73 and this section 74 till the default continues, no dividend shall be declared. So this company cannot declare. Okay, section 123 now over. Now comes section 124, unpaid dividend account. Section 124, unpaid dividend account. See, dividend declared within 30 days. If it is not paid or not claimed by the shareholder, here dividend declared day 1, day 30 dividend is not paid by the company or not claimed by the shareholder, then within 7 days it has to be transferred to unpaid dividend account within 7 days. So here whatever the unpaid or unclaimed amount transferred, let's say on 7th day only they transferred, this has to be transferred to unpaid account from the here within 90 days, from here till here within 90 days they have to put it into on, place it on website regarding name of the shareholders, unpaid dividend, and the address should be placed it on the website, and website should be approved by the CG. So company should place it, their name and the address in their website within 90 days from the unpaid dividend account. If the company made any default in the case of transfer to unpaid dividend account, then the interest will be applicable 12% per annum. Simple interest will be charged. So any default is taken place during the transfer of the amount to the unpaid dividend account, then for the such default 12% per annum interest will be charged. If the compliance is not done with regard to this section, failure to comply this section, then company has to pay 5 lakhs to 25 lakhs fine. What about the default officer is punishable, fine minimum 1 lakh to may extend to 5 lakh rupees when they are not comply with this section 124. Next comes transfer to IEF. That is the next step. From here unpaid dividend, from the unpaid dividend account up to 7 years or more, it still unpaid or unclaimed, then this from 7th year this has to be transferred to IEPF, Investors Education Protection Fund. All the shares with regard to this dividend should be transferred to the IEF, but the claimant of shares, when shares are transferred to IEPF because of this holding 7 years or more, or unpaid or unclaimed for more than 7 years, then statement of shares should be given by the company. If any claimant of shares comes, he can withdraw that share from the IEPF. Only the share, not dividend. If Mr. X, example, Mr. X dividend is unpaid, unclaimed, first year okay, first year, second year, 3 4 years are over, end of the 4th year he come and collects the dividend, so claimed by the Mr. X. So that time his shares will not be transferred, will not be transferred to IEPF because he claimed within the 7 year. I hope you understood this one. We'll make a certain changes in the example. Mr. X not claimed his dividend till consecutive 7 years, then his shares will be transferred to IEPF. You may have a certain doubt that what about his voting rights? Correct. What about his voting right? His voting rights are frozen, not to be taken into account. Account in calculation of voting. So whatever, until he claims back, until he claims back the share from the IEPF, even though this is out of syllabus, but not taken into account in calculation of the voting. That means is, for example, 30% are not claimed, then 70% will convert it into 100%, then this will be calculated. But you can argue that again out of syllabus. If you go to the rule 6 of the IEPF with regard to the SEBI, substantial acquisition shares and takeovers regulation 2011, that says shares which have been transferred to IEPF authority shall not be excluded. That clearly says shares that are with the IEPF authority, that shall not be excluded. So that is with regard to the total voting rights. This will not come for exam for general point of view. Okay, next comes section 125. Section 125, that is IPF. Section 125, Investor Education Protection Fund. We'll see later on. We'll move on to section 126, that is a right to dividend. Right to dividend, rights shares. and bonus shares that to be held in abeyance pending registration of transfer of shares. For example, Mr. A transferred his share to Mr. B. XYZ Limited. So transfer deed has been delivered. Transfer deed has been delivered to company for registration, but registration is in process, not done. Registration is pending. So at that time, who will receive the dividend, who will receive the shares, right shares, who will receive the bonus shares? That is the crux of the provision. So at that time, dividend should be transferred in relation to such shares to unpaid dividend account. In this case, this is the in process, correct? These are in process, pending for registration. In that time, dividend shall be transferred to unpaid dividend account that we discussed under section 124. So unless company is authorized by the registered or is a registered holder, so unless this Mr. A registered shareholder, he writes in writing, he says please pay to Mr. B, then transferee will get the dividend. In that time, it should be kept in abeyance. In relation to such shares or any offer right shares or a bonus shares, dividend will receive by the Mr. B. Shares, right shares, bonus shares will be kept in abeyance. So this is with regard to section 126. Next comes section 127. Section 127. Punishment for failure to distribute the dividend. Okay. Dividend declared at this point within 30 days from the date of the declaration, not been paid 30 days, it is not paid, where the dividend has been declared by the company but not been paid, or the warranty in the respect of thereof not been posted. So to any shareholder entitled to the payment, at that time, what is the punishment for that? So in that case, every director of the company knowingly a party to the default, then is a punishable imprisonment, very harsh punishment. Imprisonment may extend to 2 years. So because it is his responsibility, right? and the fine imprisonment extend to 2 years, and the fine is 1000 rupees for every default continues. Rupees 1000 for every day during which such default continues, and the company shall be liable, 18 percentage simple interest. So for the company, 18 percentage per annum during which such a default continues. In case for a director, imprisonment and the fine. Imprisonment extend to 2 years, fine rupees 1000 every day when default continues. Is there an exception for this? Yes, there are exception for the above provision. The first exception is it is done because of operation of law. In that time, excuse is there. So where the dividend could not be paid by reason of operation law, or where a shareholder has been given a direction to the company, shareholder given the direction to the company, but company could not follow the directions, could not follow the instruction, and very important, informed or communicated to the shareholder with regard to the not following the instruction. That time also director are not responsible. This we can say with regard to the R. I give an example. No, Mr. A transferred to the Mr. B is a registered transferee. It is in registration is in pending. Given the instruction to the company to give, but the instruction is not followed. This time, this is possible. Keep in abeyance unpaid dividend account. So what are the next exception? Next exception is the when there is a dispute with regard to the right to receive the dividend. Dispute is there with regard to the right to receive the dividend. At that time also, director is not responsible for the payment. There is no punishment is there. Then when the dividend is lawfully adjusted, that time also lawfully adjusted unpaid shares that are adjusted. And the last point is, that is the point number 5, where any other reason the failure to pay the dividend or to post the warrant within the period under this section was not due to any default on the part of the company, not because of the company's part, not due to any default of the part of the company. So extreme circumstances, if it is not default of the company, then company is not responsible. So these are the 5 exceptions to the section 127, punishment for failure to distribute dividends. Next comes we left out one, IPF, section 125, investor education protection fund. Section 125, investor education fund. So subsection 1. So CG will establish IEPF, that is subsection 1. Next comes subsection 2, 125, with regard to the deposits. Deposits, grants from the central government. First one is a grant from the central government. Second, donation from the central government, or revenue account of the government. So first one, grant from the central government, donation from the central government, revenue account. Then IEPF old account, that is previous years under section 125C of the Companies Act, old Companies Act, that account. Then you will get interest on this fund, no, that will be deposited. The matured deposit, matured debentures, matured deposits, matured interest, matured debentures, redemption of the preference shares, whatever the interest is there arriving from that all invested or deposited in the IEPF. And the application money also, application money for this 7 years required. Then comes subsection 3, 125 3, that is the utilization. First, that repayment of what and all we first said, mature deposit, matured debentures, repayment of mature deposit, repayment of the mature debentures, repayment towards the unclaimed or unpaid preference shares or accrued on them, is all repaid. Then investors, for promotion of the investors education, promotion of investors education and production, for that also amount utilized. Next comes subsection 4, section 125 4. This is application to authority, to claim funds. So whatever the mentioned, they have to apply to the authority in order to get matured debentures repayments. So they have to apply, paying certain fees that will covered under section 125 subsection 4. Authority, we need authority, that means section 125 subsection 5, authority for refund of the claim. Refund of claim. So we have 3 chairperson, not more than 7 members, not exceeding 7 members, and the CEO. Then comes subsection 6, 125 6, management and administration. Who will appoint? CG. CG has the power to appoint chairman, appointment of the members, appointment of the CEO, and the giving the rules and regulation. It is the CG, that is these people will authorize to manage and administer. Then comes subsection 7. CG have the powers to provide resources to these people. Resources, officers, that and all. That is subsection 7. Subsection 8, These authority, subsection 8, section 125, subsection 8, these authority people will administer the fund and maintain the record as per CAG need. Whatever the CAG provides has to be maintained and recorded. That is section 125(8). Next comes 9, subsection 9, spend of money out of this fund. Authority will spend the money according to this section 125(3), that is the objectives specified, who can use repayment and the promotion of investors. So as objective specified in 3, amount is spent by the authority, that is subsection 9. 10, audit. Who will do the audit? Of course, CAG will give the scope, time and all of the audit, and the record should be passed to the CAG, audited statements. And the last point under IEPF, Investor Education Protection Fund, that is section 125, subsection 11, reporting to CG. So annual report prepared by the authority should be given to the CG, and the CAG report, audit report, will be given to the CG. So this is the end of the chapter dividend. So we seen from the beginning dividend declaration of the dividend, subsection 1, section 123, subsection 1, sources, current year financial profit, previous year financial year undistributable profit, both 1 and 2, proviso amended, profit, unrealized gain cannot be included, notional gain cannot be included, revaluation of asset, that carrying amount of the assets and liabilities measured at fair value, that changes should not be included, money provided by CG or SG in pursuance of guarantee by the government. So subsection 1, then we see whether it is necessary to transfer certain percentage of profits to reserves, then whether it applicable to all companies, whether how to depreciation loss and business losses are set off out of accumulated surplus, dividend out of accumulated surplus in case of inadequacy and absence of profits. And 4 rules are there: a rate rule, withdrawal rule, usage rule, balance rule, and the interim dividend. Section 123, subsection 3, amendment also is there in this case. Interim dividend, profits of the current year, surplus in the profit and loss, that is a previous year accumulated profit. We seen that also in case of loss also we seen it cannot be higher rate of the immediate previous 3 financial years. Then deposit of the dividend, subsection 4, interim dividend, scheduled bank, separate bank within 5 days of declaration of the dividend. Then the payment of dividend, subsection 5, cash check, dividend warrant in electronic mode given to the registered shareholder or his order or his banker. Can dividend paid in kind? No. Subsection 6, prohibition, section 73, section 74, section 124, unpaid dividend account within 20 days, transferred within 7 days after the 30 days if it is not paid or claimed to the unpaid dividend account, and within 90 days it should be placed it on website with the name of the shareholder and address. Non-compliance or any default in the transfer to the unpaid dividend account, 12% per annum interest. No compliance of this section, 5 lakh to 25 lakh company will have the punishment or a fine. Default officer 1 lakh to 5 lakh rupees. Then within unpaid dividend account to the transfer to the IPF after 7 years. Voting rights, section 126, right to dividend, rights shares and bonus shares to be held in abeyance and pending registration of transfer of shares. Section 127, punishment for failure to distribute dividend, 18% simple interest or imprisonment extend to 2 years, fine rupees 1000 every day in case of default continues. Exception, operation law or a shareholder given direction to the company but the company could and same communicated to the shareholder. In case of dispute with regard to right to receive the dividends, lawfully adjusted or not due to any default of the part of the company. These are the exceptions. Next comes section 125, IPF, Investor Education Protection Fund. Subsection 1, establishment of the IPF. Subsection 2, deposit utilization. Subsection 4, application to authority to claim funds. Subsection